It is the purpose of today's seminar to focus on housing for people with mental and/or developmental disabilities in an attempt to further the rights of these individuals to live independently, to build self-esteem, and to generally have the same housing opportunities and responsibilities as other people. As some of you may know, the Rehabilitation Act of 1973 was the first major congressional act that addressed the need for equality of individuals, then called handicapped persons, so that they could achieve equal opportunity in programs and institutions who receive federal financial assistance. In 1988, the Fair Housing Amendments were enacted, and 2 years later, in 1990, the Americans with Disabilities Act was signed into law. Both extended this area of law to cover not only governmental entities and others receiving federal monies, but the private sector as well. Although much progress has been made, especially with respect to people with physical disabilities, such as people in wheelchairs needing access in terms of removal of architectural barriers. As of today, parity does not exist between people with mental impairments and people with physical impairments. People with Disabilities Foundation is honored to have a panel of experts consisting of Ann Levine, an attorney with Mental Health Advocacy Project in San Jose, who specializes in eviction defense and reasonable accommodations for people with mental health and developmental disabilities. Second, it is my pleasure to introduce Mr. Michael Rossoff, an attorney in San Francisco, who specializes in the legal rights of landlords, especially with respect to evictions. Mr. Rossoff is a former commissioner for the Rent Control Board, and he has been practicing for 23 years. Third is Fred Nisen, a staff attorney with Protection and Advocacy in Oakland, California. As he has an expressive communication disability, he will speak through an interpreter. And lastly, we are pleased to have Victoria Tedder, a housing counselor with the Independent Living Resource Center of San Francisco. And I am pleased to introduce People with Disabilities Foundation's founder and executive director, Stephen Bruce, has spent the past 2 decades as an advocate for those with disabilities. He is admitted to practice before the Supreme Court, the United States Court of Appeals for the Ninth Circuit, several United States district courts, and the states of California, Florida, and the District of Columbia. Mr. Stephen Bruce, who will moderate this seminar and begin the questioning of our panel of experts.
In this recording, with the permission of Mr. Nisen and Mr. Rossoff, their voices have been re-recorded by interpreters for clarity.
Ann Levine, what is the current status of the law for housing, paying particular attention to people with developmental and or mental disabilities?
I'd be happy to touch on that. First, they define it as somebody with a mental or physical impairment that substantially limits one or more major life activities, and that can be seeing, talking, walking, working, or caring for oneself. That actually is meant to include alcoholism, and it's also meant to include past drug use, but not present use of an illegal substance. Another definition of disability under the ADA and the Fair Housing Amendments Act is having a history of an impairment that substantially limits one or more major life activities. We're all going to recite this later. This could include past hospitalizations or even a bad tendency history that's due to a manic episode, maybe because of somebody's bipolar affective disorder that wasn't stabilized on medication in the past. The third definition is being regarded as having an impairment. An example that I use is if a landlord finds out that somebody is gay, they may also assume that because they're gay that they are HIV positive or that they have AIDS, and that might fall into the category of being regarded as having an impairment that substantially limits one or more major life activities. The exclusions however, because there are three, are that there's a direct threat. So let's say that somebody does have a mental health disability, but a landlord would say that they're not covered by fair housing laws because they present a direct threat. Well, actually, the analysis needs to be whether or not they present a direct threat that no accommodation could prevent or could cure. An accommodation, which Fred Nisen will talk about in just a few minutes, is a change or an exception to a landlord's normal policies or procedures that someone with a disability may need to enable them to fully use and enjoy their dwelling. And if no accommodation could prevent the direct threat, so the direct threat remains, then they may not be entitled to live in that housing despite having a disability. Another exclusion is somebody who would cause substantial physical damage to the unit, taking into account accommodations as well. And the last is that they're not otherwise qualified as a tenant. So let's say, for instance, that somebody has a bad credit history that would show the landlord that they're not able to pay their rent on time, and that isn't related to their disability. Then they may not be otherwise qualified to be a tenant. In June of 1999, the Supreme Court decided a trio of very important cases. The cases really involve people, for the most part, who had disabilities that were treatable with various kinds of assistive devices. Well, the Supreme Court decided that the definition of disability needed to be construed in taking into account whatever assistance or medication or therapy or adjustments somebody had made to help with their disability. So in looking at somebody who might be wearing glasses, you look at whether or not they were disabled with the use of their glasses.
And with respect to the definition of substantial life activities, is state law any different than the federal law you just described?
It's actually less restrictive. There were some amendments that were made in 1999 to the FEHA, the Fair Employment and Housing Act, and it actually expanded the definition of disability. For instance, under FEHA, mental disability includes somebody having a mental or psychological disorder that limits a major life activity, not substantially limits. It also says specifically in the law in California that the limits should be determined without regard to mitigating measures such as medications or assistive devices. But if somebody's on some kind of medication that has a really bad side effect that causes a limitation in their daily life activities, that side effect can be taken into account to determine if they qualify. So kind of get the best of both worlds in that. It also defines limitation very specifically. It says that limitation means making the achievement of a major life activity more difficult. So it really sets it out that it's not meant substantial or to a large extent, and just means it makes it more difficult. It also says that major life activities shall be broadly construed, shall include physical, mental, and social activities, and working.
And Levine, if an individual is taking medications that help alleviate the symptomology in major part, do they still receive the protections under state law?
It's very clear from FEHA, the Fair Employment and Housing Act, that somebody is supposed to be analyzed as having a disability without consideration of those mitigating measures. The only time the mitigating measures are supposed to be considered is if the side effects are causing the disability. But yeah, it's very, very clear from FEHA, you're supposed to look at it without regard to mitigating measures.
And are there any restrictions on the amount or scope of the questions a landlord can ask of a prospective tenant?
Great question. Well, first thing I want to say is landlords should not ask questions about a person's disability. It does not go to the main gist of what they should be asking these tenants, which is, will they be able to be good tenants? Will they be able to pay their rent on time and take care of their property? It is really inconsequential whether or not they have a disability, and the mere asking of the question, do you have a disability, or are you taking medication, or are you in therapy for that depression? All those questions are discrimination. Now, the only time somebody can ask a question about whether or not somebody has a disability when they're applying for housing is if it's a housing provider that specifically is providing housing to people with disabilities.
Doesn't the landlord have a right to inquire into the nature of a tenant's or applicant's disability in order to be satisfied that the tenant has the ability to pay the rent?
The first thing is that a landlord is allowed to ask what somebody's source of income is in order to verify that they're going to be able to afford the rent and pay rent on time. However, under California law, under FEHA, they're not allowed to then refuse to rent to somebody on the basis of what that income is. So a landlord, once they find out that somebody's on Social Security income, is not able to say, oh, we don't accept people with SSI or SSDI. Additionally, of course landlords are allowed to ask if somebody is going to be capable of complying with the lease terms, because that's really critical for landlords to know. And landlords are able to look at tenants' former or prospective tenants' former history, tenancy history. They're allowed to look at their credit report, and past evictions will appear on these tenant reporting agencies, often appearing on the credit reports themselves. So those are very important ways for them to be able to see if somebody is going to comply with the lease terms. However, they should ask these questions about people's ability to comply with the lease terms in the same way to all people, regardless of whether or not they have disabilities. The fact that somebody has a mental health or a developmental or even a physical disability does not mean that they are less likely to comply with the lease terms. And it's that kind of stereotyping that I think all of these fair housing laws are meant to protect against.
And Levine, if it appears to an individual that in fact they are the victim of unlawful housing discrimination, is there any way to preserve the apartment that they wanted without first having to go through court and possibly through the delay associated with litigation and a trial? For example, could they get a restraining order, or what would you advise them to do?
Well, they can always call me or another attorney who works in the community who will often go out and talk to these landlords or property managers and explain the fair housing laws to them. Sometimes there are decisions that they make without fully understanding what their responsibilities are and what the laws are. And we've often been able to get tenants into different housing when at first they had been refused, short of filing a complaint or a lawsuit. There also are fair housing agencies that can do testing to see if there is some kind of discrimination, if they can to confirm that there's some kind of discrimination going on the basis of disability or any of the other protected categories like source of income or race or ethnicity or marital status.
As to harassment in housing, which is similar to harassment in the workplace, it is generally considered illegal discrimination if it materially interferes with the disabled person's right to peaceful and quiet enjoyment of the premises. This is based on both landlord-tenant law and also anti-discrimination housing laws. I'd now like to switch gears a little bit and bring Mr. Fred Nisen into the discussion. Fred Nisen will be talking about reasonable accommodation as it relates to housing issues. Fred?
Like Ann said, the Fair Housing Act requires housing providers, including landlords, to make reasonable accommodations in rules, policies, practices, or services to people with disabilities in order to give them equal opportunity to use and enjoy their home or common space. Now, before a person gets any reasonable accommodation, what do they have to do? The first thing you need to do is make a request to the landlord in writing. It should include a description of how your disability affects you and why you need an accommodation. You also need to include documentation of your disability and how your disability requires an accommodation from your doctor or other health professional. I also always recommend that at the end of that letter, you include a sentence saying something to the effect of, "If I do not hear from you within a certain number of days, usually 10, I will assume that my request is denied and take appropriate action." If the request is denied, you can file a complaint with either the U.S. Department of Housing and Urban Development, HUD, or with the California Department of Fair Employment and Housing. The phone number for HUD is 800-347-3739. And the phone number for DFEH is 415-557-2325. And now I will show an example of reasonable accommodation, which is someone with mental retardation comes in to apply for an apartment, but they can't fill out the application. It would be a reasonable accommodation to have the landlord help fill out the application. Next is the one I get called about all the time, is the no pet policy. If you have an assistance animal, that is, it could be a hearing dog or seeing eye animal, but also for emotional support.
Fred, how much documentation can a landlord require if an individual, for example, needs an assistance dog or is hearing sensitive and needs soundproofing? Just how far can a landlord go in requesting documentation?
Well, I think that it depends on the case. But the landlord is entitled to proof of disability and proof of the connection between the disability and the need for the dog.
So you're saying it's enough to have evidence of a disability and a connection with the accommodation in order for a tenant to have met his burden?
Man.
Michael Rossoff, assume the same two examples. First, an individual who needs soundproofing in his apartment because of a hearing sensitivity, that he's going to pay for it himself and get a licensed contractor. And number two, assume that a tenant would like to have a therapy dog, not for assistance so much, but to give him emotional support and to enable him or her to live independently. What is the landlord's perspective? Are doctors' notes or letters sufficient?
For most of my clients in San Francisco, a note from the tenant is sufficient. But sometimes where there's been a history of deceit by a tenant, we do request a doctor's letter and we often get it. And if so, allowance is given for the pet. That's my advice to my client, pertinent to provide emotional support. Just because someone's played games with the landlord in the past or been deceitful doesn't mean they don't have a disability that requires a pet. Those are the easy cases. The more difficult cases would be soundproofing, because most properties, at least in San Francisco and in the Bay Area and Northern California, are very difficult to adequately soundproof for people who are deeply sensitive to sound. And in the category of sensitive, it would be very expensive and I believe too great a burden to the landlord to bear. I personally don't know of any cases where the tenant has covered those costs. It's usually less expensive, even with the great disparities in rent, simply for a tenant to move to a more modern construction to get that silence.
Well, Fred, what if there was a counteroffer from the landlord and there was another apartment available that was not quite as nice, didn't have quite the view the other one did, maybe it was a little smaller, but nevertheless, it did satisfy the need for the accommodation. Would this be satisfactory to your client?
The problem with that
is, as Anne was alluding to, that might be considered steering.
Well, Michael Rossoff, Fred Nisen says it's steering. What is the landlord's position in cases like this?
My concern with the lovely Victorians in the city, where some people move in and want it soundproofed, and it could be done, but it's very expensive, and it would require sheetrocking over plaster and detailing and molding that would destroy the aesthetic value of the property. It could be possibly moved out when the tenant vacates, but at a great cost. It's very difficult to get the money up front to secure the restoration because we're simply limited with the amount of deposits we can get from the tenants. So just the negotiation to determine in advance what the cost would be is usually too great of a burden for the landlord to take, at least as far as the advice that I would give my landlord client. When you're balancing the accommodation versus a problem it causes for the landlord, it's usually easier for the tenant to find more modern adaptation, and whether that's steering or not, I guess would be a tribal issue, but I don't believe it is.
Michael Rossoff, what if the tenant removes this issue by putting down a lot of collateral, either a lot of money or other assets, to ensure that the Victorian or other beautiful housing is restored to the way it was before? Would that resolve the issue?
Whether we like it or not, I'm glad it's still this way in California. Maybe not so much in the Midwest, but aesthetics do mean something. It has value. It's why a lot of people move to San Francisco. It's because of the value in the architecture that thousands of workers put in, which were built in these last 150 years, and to destroy it, to make an accommodation for that specific location, I think it's an unfair burden. I don't think it would ever come to an actual court case, because I think if the landlord and tenant sit down to consider aesthetics, they'll come to an accord. These are the very things that make San Francisco unique.
Victoria, do you have any experience or opinion on the subject, that is, modifying a structure and changing the design, the Victorian design, in order to accommodate a tenant?
With the sorts of clients I've got who are typically very poor, there's virtually no chance that anybody's going to be able to come up. If you're talking about, obviously, if you're talking about non-federally funded housing, non-government funded housing, the tenant would have to come up with this incredible amount of money. And when I've had people have this sort of problem in the past, whether they were the one that was bothered by noise or the one that was creating noise, we've typically found other things to do. In one case, and actually this is one of my favorite cases, there was a man who heard voices, and if they got particularly bad, he would argue with the voices out loud. And this bothered his neighbors when it got really bad, and apparently this was not totally controlled by his medication. And somebody brought him in, and we sat around, and the other person said, well, maybe we could soundproof his, he didn't even have a whole apartment. It was like a room with bath. And I said, where would we get the money? And I don't think it's going to work. What else can we do? I said, well, is there anything that helps maybe, so when you're not, so that you don't make the noise? He said, well, during the day I can just take a walk if I'm feeling bad. I can walk in the park. And I said, well, you can't do that at 2 a.m. You live in the Tenderloin. Does anything ever work when you get in the middle of the night? And he said, well, if I call suicide prevention and I get somebody really good, they can talk me out of it. They can talk me down. And I said, well, what if you had somebody living with you who could talk you down? Would that work? And he said, gee, I guess it would. So we wrote a request for an accommodation to the manager, and this actually was a federally funded building. Unfortunately, the manager had gone to some sort of fair housing training. So we said, can this man have a live-in attendant, or at least a night live-in attendant, to help him? And we enclosed a doctor's letter saying that we really needed to have an attendant for the man because A, he didn't want to bother the neighbors, and B, if it escalated, he would sometimes get so bad that he would start hitting himself with his fists. So we said, let's try this, let's see if it works. I met the man a couple weeks ago. He's still there. He got somebody to be with him at night. So, especially if you're dealing with low-income clients, that's more likely to be the sort of thing that you're doing. I don't know about the other counties, but in San Francisco County, there really is no good source of funding for modifications for a tenant. For a landlord, not a landlord, but rather a homeowner, even a condo owner, you can go into programs like, I can't remember what they call it this year. They used to call it Christmas in April. But there really is no comparable program for tenants. I've had some luck with tenants who were bothered themselves by noise getting white noise machines. And a good white noise machine will set you back about $80, which is certainly a lot cheaper than trying to modify either your apartment or the other person's apartment. Actually, I use one myself. So, yes, modifications are important, and I think they're wonderful. But especially when you've got everybody living very close together in hotels, in row houses like I do, quite often a modification may not be what you're going to be doing for a noise problem. You know, that's actually one of the very, very early cases, early federal cases, was a case called Citywide Associates versus Penfield. And Eleanor Penfield was a schizophrenic who heard voices coming out of her walls, and she dug little holes in the walls, and they started evicting her. And the judge said, well, up to now she hasn't really caused that much damage. It was less than 1 month's rent. It was covered by her deposit. You know, you haven't even explored the possibility of having her get back on her medication. And, you know, again, I'm sure anyone who works with people with thought disorders knows that a lot of the medications they take, it's a great temptation to go off them because especially the early medications had such horrible side effects. And so what the judge ruled in the Penfield case, the citywide case, was that they should give this woman some time to go back on her meds and see if she could correct this behavior.
I would advise a client that would be a reasonable accommodation whether their medication is currently working or not. The kind of accommodation is done all the time. It's just a good and decent thing to do.
Assume we have a tenant with a diagnosis of vascular dementia. Further assume that he's not at the point where he needs to be watched, for example, in order to make sure that a gas stove has been turned off. So as of this point in time, there are really not safety considerations, and he certainly does not want or need a 24-hour care taker. However, this syndrome, dementia, is progressive, and there's no doubt that it will lead to the need for a caretaker for safety and other reasons. What are the rights and obligations of the parties? How would you evaluate this situation?
That it's reasonable, a reasonable accommodation. But the only problem that I can see the landlord having is that the apartment may not be big enough for 2 people. I would say that the landlord would have to prove it violates some safety code. They then might ask you to move to a bigger apartment. Otherwise, they would have to allow it.
Michael Rossoff, same question to you.
It would be just that one concern regarding the safety of other people. But if a tenant were capable of independent living, but with a live-in caregiver, then I believe the landlord would lose, and the tenant would be able to stay. So the landlord would be advised to essentially hope and pray that the tenant could live there peacefully with a live-in caretaker. The landlord would have liability because if there was to be a fire, if it could be proven in a wrongful death suit by the tenant that the landlord had reason to believe that people could die because of the situation in the disabled tenant's apartment, he can be held civilly and criminally responsible. So there's a very tight balance that has to be weighed on each one of these cases. So it's best to advise the landlord to document his or her knowledge of the situation in order to show they had no reason to believe there was the likelihood of a fire happening. That's usually the concern, especially with gas stoves.
You may be able to also train a service animal to sense for a gas leak or some kind of fire and bark or something like that.
Certainly, smoke detectors and carbon monoxide detectors would be helpful.
Now, is there any fund through any of your programs which would immunize a landlord from any damage that one of your, a tenant who might be one of your clients might have on a unit and not be able to personally be responsible for? Is there any way that a landlord could be assured that if I do rent to a person who might be on disability, might have some problem, but who obviously doesn't have a lot of financial resources, that any damage that will be done will be able to be repaid to him or her?
No. One of the assumptions that seems to me to underlie your question is that people with disabilities are more likely to cause damage to a unit than somebody without a disability, and I think that that's wholly untrue. Actually, in terms of statistics on things like violence, people with disabilities are less violent than people without disabilities. And so I think a lot of the stereotypes and assumptions that the large proportion of the community has about people with disabilities is largely unfounded. The way to compensate yourself as a landlord for those damages that any tenant causes to a property is through a security deposit.
And Levine, what if you have a situation where there's a landlord who discriminates against disabled people very surreptitiously? In other words, it's so covert that it's really difficult to get evidence to use in any case, administratively or in court. Are there any methods by which evidence could be obtained that can be used to show discriminatory pattern and practices on behalf of a particular landlord?
I think it is possible, but it's also very difficult. Fair housing agencies provide testers for situations like that, where they would send out two different people, one person bearing the exact same or in the exact same situation as the person who felt that they were discriminated against, and then the second tester being somebody just like that person, but with the different characteristic. If it was a discrimination on the basis of disability, the second tester wouldn't have the disability. If it was on the basis of race, the second tester would be of a different race. And if the landlord chose one tester over another, that may be evidence of discrimination. So there are ways to test for it. You also can do surveys in a housing community, maybe an apartment complex, to see if there are rules that the landlord has that discriminate against people on any of the protected basis. You can oftentimes find out a lot of interesting information doing surveys. So there are ways to test for it, and frankly, also some landlords do make those really outrageously discriminatory statements to wrong people like me. So there are ways, but it is difficult.
I happened to be in Washington, I guess it was 2 years ago, and they were arguing a case, or this oral argument, a case called Olmstead versus the state of Georgia. And this was an interesting case because in the Americans with Disabilities Act, one of the concepts, the central concepts to the act, is that disabled persons be integrated to the maximum extent possible within the community. And this issue has arisen here in California and other places in different ways. I believe it was during the Reagan governorship years when they decided to close down a lot of state mental institutions. The idea was that the community-based health service systems would be better for not only the patients, but would be better in terms of funding. Unfortunately, what has happened since then, and since 1967, which was when the Lanterman-Pettis-Short Act, more commonly known as, I guess, Section 5150, was passed, is that we have a lot of people in our community who pass the standard of not being able to involuntarily be confined in a facility. And basically, whether it's in California or any other state, the standard is very similar. That is, if an individual cannot care for their own safety or the safety of others, in other words, is either dangerous to themselves or others, then they can be held for up to 72 hours, at which time they get, well, in California, it would be it's a 5150 hearing. When I was a public defender in Florida, it was a Baker Act hearing, and then there's another period of time that someone could be held in a psychiatric ward.
14 days.
Is it 14 days?
It's 14 days.
There are lots of issues that come out of this, especially when considered in the context of the Americans with Disabilities Act, in particular Title II, as it was applied to the Olmstead case, which basically was a case involving two women in the state of Georgia. One's diagnosis is paranoid schizophrenia, and the other one had another diagnosis. I don't think it was schizophrenia, but it was some other.
It's a personality disorder, and both had mental retardation.
And both had mental retardation, and they were, and this it was interesting, I happened to be sitting at oral argument there, they voluntarily admitted themselves into a psych ward. However, they could not voluntarily leave at any time, at least not for 72 hours. And there was a lot of discussion at oral arguments about what is that supposed to mean, but it really wasn't so important to the case. What was important to the case was that the psychiatrist on the side of the state hospital, had agreed with the psychiatrists who were on the side of the individuals, the disabled individuals, that they in fact would be better off in an integrated community setting. And there were certain, for lack of a better words, waiting lists or lines or procedures on how to get spaces within the community as opposed to a state hospital. So the 11th Circuit ruled basically that Title II mandated a state to offer these two women treatment in the community, and that was based on the medical evidence of the psychiatrists on both sides. Now, the state of Georgia complained and appealed it to the Supreme Court, and their attorney kept saying to the justices, well, there's a numerator but no denominator. In other words, everybody then will have to go into the community system so long as they call them professionals, who are the expert medical doctors or psychiatrists, or we can say hired guns, you can, however you want to describe them. So what the Supreme Court basically did, and it is a handout outside, it's known as the Olmstead case, is they upheld the 11th Circuit. However, they listed a lot of other factors so as to give states some kinds of other defenses, basically relating to hardships that weren't readily apparent in this case, but could be in other situations, so like states would not automatically, according to them, be forced to provide community treatment, residential treatment for anybody just because the psychiatrist said they would do better. The concept of the Olmstead case, and that is integration in a community setting to the maximum extent possible, is very central to the seminar, Housing for People with Psychiatric and/or Developmental Disabilities, as it is to any kind of disability rights, whether it be employment or education or anything else, the concept being integration. But there are some practical problems, one of which Justice Rehnquist pointed out at the hearing, at oral argument, said, well, what if the state hires some more professionals, in other words, psychiatrists who work for the hospital, who are told they need to fill more beds, then what's going to happen? Because if that's the rule, then these people won't get to the community. They'll have to, just weigh how many psychiatrists are saying what. But putting that aside, the decision from the Supreme Court did come down in this Olmstead case, which is printed and available outside, and it mostly upheld the 11th Circuit. These two women did have a right to be in the maximum integrated setting, community setting possible, but with some modifications so that the state of Georgia and now the other 49 states too could at least raise defenses so in their view they're not overburdened by having just to place everybody out of state institutions. But what I wanted to raise for the purpose of this seminar is a whole class of people who cannot live independently in their own apartments, but on the other hand, they certainly don't fit the criteria to be 5150 or involuntarily confined. A lot of these, and there's been a lot of press here in the city and county of San Francisco about people who are going through the revolving door of the psych ward, where they get food and a place to sleep, obviously. And one question is, and the first question is, are there transitional services provided for these people, and to what extent? In other words, they don't qualify under the danger to themselves or others standard to be confined in the hospital, but they need ongoing and continuing services, whether it's psychotherapy and or medication, before that they can really live independently. So they're sort of in an in-between state in terms of their housing needs. So I did want to ask Victoria Tedder first if you have any input about the scope of this problem, if you agree that it is a problem, and secondly, what remedies there are for this group of people.
Well, being a housing counselor, I tend to see things as housing problems rather than a problem that there are these people that need this level of care, although care is important. And there is just not enough housing for people, whether their mental illness is of a certain degree or a greater degree, or even of a very, very severe degree. Here in San Francisco, for example, there is a lot of housing, including transitional housing that's run by the county mental health services, but the housing is bottlenecked, it's backed up, because what used to happen, say I become mentally disabled as an adult, say I'm not diagnosed before the age of 18, I come out to San Francisco, I get a job or something, and I get more and more depressed to the point where I can't take care of myself anymore. I'll probably be hospitalized. The way it worked, say 10, 20 years ago, is I would come out of the hospital, they would put me in some sort of a halfway house, and there's a whole series in the mental health systems. We have 3 mental health providers in this county, and you go from a more restrictive setting to progressively less restrictive settings, and you get to a certain point, and you might stay in supported housing of some sort, that's housing that has some sort of program attached, or at least a counselor who comes and visits with you maybe once a month. Or you might just graduate to housing that really is not exactly supported housing, but that is something that you can afford. And there used to be a whole progression that people would go through, and some people have managed to go through. You talk about the revolving door, and it's certainly true, but being homeless, having no regular place of your own, makes you crazier. I've been homeless myself 3 times, Fortunately, not the kind where you're on the street. I always had enough middle-class friends with apartments that I could sleep on somebody's couch. But having no regular place of your own is going to make your mental illness worse if you have one, and it may give you a form of traumatic stress. Later you'll have post-traumatic stress just from being homeless. People will decompensate if they don't have good housing. And also, as has been mentioned, it's going to be tempting for me to want to decompensate if I know by decompensating I can at least get onto a locked ward for a week or two.
A couple of weeks ago, there was a demonstration near my office in Civic Center. There was a large group of people demonstrating about the residents of Laguna Honda Hospital, which is a facility where people live and also receive medical and other services. Being near my office, I decided to go out and talk to the people and ask them exactly what it is that they wanted. And it was explained to me that they wanted their right to choose to live where they wanted to. In other words, their right to live independently. As of January of 2002 in California, the SSI monthly check amount is $750. And so I asked one or two of them exactly where it was that they planned on living and how they expected to also get the provision of medical services that they required. And in general, they said that they didn't really care. They just wanted the freedom of choice and the right to live independently. Does anyone in the audience or on the panel have any comments on this issue?
I'm Nancy Brown. I'm with the ARC San Francisco. As far as people with developmental disabilities are concerned, they are entitled to individualized services under the Lanterman Act. So they are entitled to services to help them live as independently as possible, whether that means someone coming and meeting with them once a week to go over budgeting and cooking and safety, or if it means that they need to have someone support them 24 hours a day. So they are entitled to that under the state law. There's already a funding mechanism for that through the Golden Gate Regional Center. The Golden Gate Regional Center brokers for services. Mm-hmm. As far as what is our responsibility for providing housing and services, I think we have a major responsibility for providing housing, and I think it's in the interest of all Californians and particularly people in the Bay Area to do this, because facility care is incredibly expensive, and you can get higher quality care for less cost with more freedom in the community. If you're looking at Laguna Honda, I think the figure was something like $90,000 per person. Mm-hmm. Ridiculous. Developmental centers are even more expensive. So you're talking about a vast sum of money for services that are more restrictive. They're not necessarily higher quality. They're not what people want. So we're better off investing in housing and that meets people's needs. And in the long run, we're all going to both save money and increase integration that way.
Nancy, let me just follow up on that. So if someone wants to move out of Laguna Honda mm-hmm. and get an apartment, let's say the mission is fine, it's acceptable, but their own apartment, in terms of the attendant services that they were getting at Laguna Honda, therapies or other things which they really can't do by themselves, are you saying that there is a mechanism in place that will send the social worker or other caretaker services to people at different locations within the city?
If that individual has a developmental disability as defined under California law, which is if they have a disability that began before the age of 18, that's mental retardation, cerebral palsy, autism, epilepsy, or conditions similar to mental retardation that limit one substantial major life activity. If they have a different type of disability, they may not be entitled to the same sorts of services.
And where do they go to apply for the support once they've managed to negotiate a lease? Is it IHSS type support administered through the county by the state?
You raise a complicated question. There are services specific for people with developmental disabilities, and then there are what they call generic services, where people, anybody can apply, or people of all different kinds of disabilities can apply. You're mandated under the supported living regulations that anything that can be covered by a generic agency like IHSS can help people with all different sorts of disabilities has to be covered by IHSS. So if you need house cleaning, for example, and that can be done by IHSS, that's done by IHSS. But the things that cannot be done by IHSS that are maybe specific to having a developmental disability, social integration activities, or forming a circle of support in the community, education about health issues, those types of things that are not covered by IHSS would be picked up by a person's supported living plan. And generally it's arranged by that person and a team of support, usually the regional center case manager. Everybody who has a developmental disability is part of the regional center system, and then often different service providers, family members, friends, advocates, and the like.
So this network, let me just follow up, and Fred, I promise you can go next. If someone wants to live outside of a group home, administered or licensed by a community care licensing facility, there is in place a sufficient, in your opinion, network of supports, or is this something that is hopefully going to be done?
It is available. You have to advocate for it through your regional center system. Some regional center systems, it's easier to advocate for it than others. But it is under state law. You do have the right to ask for all of these services. So that, at least from the legal standpoint, it's there. Sometimes you have to push.
Okay, Fred.
Protection and Advocacy is one or more agencies that filed a lawsuit about the Laguna Honda issues. One of the things that we want is easier availability of waivers, and what the state can get done is to allow Medi-Cal to provide the services that IHSS may not be able to provide.
Are these waivers you're talking about any different than what Nancy Brune just described? Oh, it's a whole different system.
Well, what they describe is solely for people with developmental disabilities. In California, if they provide services to people with developmental disabilities, they need to work independently. What I'm talking about is for all people with disabilities. This state can apply for funding from the federal government.
And do they get it? The funding?
They don't apply.
Well, they don't apply, and why don't they apply?
Good question.
I mean, is it because they're unaware, or because they're discouraged from applying?
Well, right now, they can't quite admit they're unaware. They are not unaware.
The logical conclusion that would lead me to is that they really don't want the funding to live independently. They want to stay where they are. I mean, is that incorrect?
I don't know. I can't answer that. But what people might want to do is that there is a coalition of organizations that are trying to lobby the state to get these services and other services that will implement Olmstead in California as required by Olmstead.
So Olmstead is a fairly new decision, relatively speaking, and certainly...
Right, but it requires all states to come up with a plan to implement. In California, as of this date, it has not yet been done.
On a related subject, a few weeks ago I was in South Florida, the week of Christmas actually, and an individual who was living in a group home in a nice neighborhood, his diagnosis was autism, had wandered out of the house. The house had a good reputation, meaning the caretakers did a good job. It was a well-run group home. He, however, unfortunately entered into someone else's house, a neighbor's house, and was immediately strangled to death. Now, as it turned out, this individual was not violent. the individual with a diagnosis of autism. And his family members' position is that they don't necessarily blame the neighbor who's strangled him because he was a stranger in their house. But do you believe that education and sensitization to these other kinds of group home situations, is something which might resolve some of these problems? And by asking this question, I am bringing up the whole issue of not in my neighborhood, or NIMBY, not in my backyard. Yes, we need them. Yes, everyone has a right to live in the community, as we've been talking about over the last hour and a half or so. But on the other hand, just what are the practicalities of the situation? The example I used happened just a few weeks ago, but I only used that example because maybe there are some lessons to be learned from that situation.
Do I think education can resolve all possible situations of discrimination against people with disabilities? Of course not. In the same way that education can't end racism. But I think that it's a start, and it's an important start. I think that involving people who have disabilities, who are living independently, in that effort to provide education out in the community is a critical part of it. And I think that using the legal system to advocate on behalf of these people who are being discriminated against is also a critical component. I think it all goes hand in hand, but where I'd like to start is through education, is through a development of a better understanding, a breakdown in stereotypes and assumptions.
I think education is important, and I don't mean to point at Hollywood, but there isn't much that can be done in terms of film or even literature that really deals with these issues, unless it's overblown and some kind of false romance. But in terms of the day-to-day ordeals that people with disabilities have getting to school or getting to work or getting on a bus, those are hidden from us. They are not part of our everyday culture. And until that happens, there is going to be even a greater disparity. I don't think that the problem can be solved in Sacramento or without the help of Hollywood and the help of our community, churches, synagogues, grammar schools. And I'm grateful. I had a grandmother who didn't have any legs that were removed because of her diabetes. I'm grateful for learning through her as a kid, because if I didn't have that kind of experience, I don't think I would be able to understand a lot of the issues you guys are bringing to me today. And unfortunately, those kinds of images are too ugly to be portrayed on film, or certainly network television. And until that kind of truth is revealed, we are not going to have the cultural language or grammar to address these issues, and not something we can really work out in this forum. Because our skills are in the legal world mostly, but there are other layers to our culture that have to address these issues. I couldn't even write the script, but I know that what we know is what we see. And 90% of what we see is on television, and there just isn't any dealing with these issues. We've barely touched the surface on critical issues such as racism and violence, let alone disabilities.
There being no further questions, this will end today's program. If you are in need of any more information, please feel free to contact People with Disabilities Foundation. Our web address is peoplewithdisabilities.org, O-R-G, or pwdf.org, as in People with Disabilities Foundation. On behalf of the foundation, I wish to thank all members of the panel and the audience for participating in this discussion.